Okay, we'll now continue with the interviews. This one, of course, is for Family Court Department N. And we have, the judge is not here, the incumbent, but we do have Monti Jordana Levy. I want to go over the guidelines one more time. The guidelines will go like this. This is an interview, not a debate. Follow-up questions are not allowed unless for clarity. Each candidate will not, well, actually, in this case, we don't have to worry about that. Candidates are allowed 1.5 minutes to introduce themselves. Panel members are allowed 30 seconds to pose a question. Candidates are allowed 1 minute to answer. Panel members are allowed one question. This is not a forum to air personal grievances. Panel members, please keep your questions generic. And Ms. Candidate, please do not mention your opponent in the question, in your response, I should say. If you'd like to please introduce yourself.
Good afternoon. My name is Monti Levy, and I am running for Family Court Department N. I first came to Las Vegas with my parents in 1987. My father, he's no longer with us, but he was a veteran of World War II, which is why this endorsement interview means so much to me. And I thank all of you for giving me the opportunity to be here. I attended undergraduate, I got my undergraduate degree at UNLV, and during that time, I worked 2 jobs, putting myself through college. One of the jobs, I worked at the Juvenile Detention Center, and that's where I first became interested in the juvenile justice system. During that time, I also volunteered through Nevada Youth Parole, where I was a mentor for juveniles who were recently incarcerated and released back into society, and I would assist them with getting acclimated back into society, take them to eat, talk to them about the problems that they're having back in society. When I graduated college, I went to law school at Seattle University School of Law. I graduated magna cum laude, top 10% of my class all 3 years, on the dean's list every single semester. And then I did my last year as a visiting student at UNLV, and during that time I also interned at the Clark County District Attorney's Office, and then I did an internship also at the U.S. Attorney's Office. For the last 8 years, I've been a partner at the law office of Bush & Levy, where we do criminal defense, family law, personal injury. Prior to that, I spent my first 3 years as an attorney with the law office of John Monmouth, and I learned so much there doing criminal defense, and I did all of the family law for the office as well as personal injury. And then for a short time, I prosecuted at the City of Henderson and the U.S. Attorney's Office. But since then, I've been, for the last 8 years, as I said, in my own firm with my partner, and we do criminal defense, family law, and personal injury.
Thank you very much. I think we'll begin over here. This side seems to work better for me. Judge Assad, will you please begin?
Thank you, and thank you for being here. It's a compound question. You may want to expound also, give us a little more of your background. You have children, that kind of thing. What would qualify you for family court, your experiences with family court, and if you're elected to be the judge in family court, what can you do specifically to help and address the needs of veterans with alcohol and drug abuse issues, post-traumatic stress disorder issues, and anything that you may want to innovate that's not being done currently, or if it is being done, perhaps you could do it a little bit better.
Thank you. Actually, I do have children. I am a single mother of 4 children, one of whom has special needs. I've been involved as a litigant and a attorney in the family court, so I do understand the process. With regard to the veterans, I have represented several individuals who, under 176A.280, which is the Veterans Court statute for criminal court, and it gives the court's authority to have a specialty court for veterans. Now, in family court, there's not currently a procedure for veterans. They have a specialty court for drug court, so I don't think it would be difficult to add a component to the current drug court or a separate court for veterans to address their specific problems. I've represented people with PTSD and also drug problems that occurred after they came back, or people that had no problems whatsoever with drugs or alcohol prior to their service in the military, but when they came back and tried to re-enter in society, they got hooked on drugs or on alcohol, and it all related back to their services in the military. And I think that we owe it to our veterans, who are all heroes. We owe it to them to implement something to address PTSD and those issues in family court, because a lot of times it's going to affect custody determinations, and I don't think that the PTSD or drug and alcohol problems that are attributable to their service in the military should be held against them. We should be providing services to address that so that they can lead normal lives.
Thank you.
Thank you. Dr. Hawkins?
Hey, are you running because you believe you're the better candidate, and if so, why? Or because you see a problem in the current department, and if so, what?
I am running because I do see problems in family court in that specific department, and I know one of the rules is I'm not supposed to mention my opponent, but there are problems that I see in family court as a whole, and I think that there's several improvements that need to be made with that department particularly. I think that there's not enough time given to litigants to actually state their case and argue other than what's on the pleadings. A lot of times in family court, I mean, there's no black and white when it comes to family court. Everything's a gray area. And what we need is judges that actually take the time to learn more about the litigants. Sometimes the person who would be the better parent isn't the person who can hire the most expensive lawyer to write the best brief and to rule just on the pleadings. It may be efficient, but I think you have to strike a balance between the efficiency of the court system and giving the parties the opportunity to be heard. That's what family court is about. These people, they're fighting for, and we're dealing with the most important things in their lives. We're dealing with their children, their property, things that they've worked their entire lives to save for. We're not talking about criminal court where we're dealing with punishment for a crime that's already occurred, or civil court where you're trying to right a wrong in monetary means. We're talking about people whose entire lives are at stake, their children and all of their prized possessions. And so we need judges that are going to take the opportunity to listen to these people, to give them a forum so that they can discuss why. I apologize. Time's up.
Okay, thank you very much. Mr. German?
Okay, so based on your answer to the last question, it seems to me that like you're a little bit bitter that maybe you're not, as an attorney, you don't feel like you're getting enough time to state your case. If that's actually true, then isn't that incumbent upon you as an attorney to know the rules going into that courtroom so that you state your case in an appropriate manner to be heard for your client?
I understand your question, and no, I'm absolutely not bitter whatsoever. And my issue deals more with people who can't afford attorneys and people that are coming to court on their own, who have to write their own motions, who are indigent. And I think that that's where we owe it to those litigants to hear what they have to say. Absolutely, the attorneys should put all of their issues in the motions appropriately, absolutely. But I stand for the little person that doesn't have the means to hire an attorney, whose brief might not be able to, they may not be educated enough to write, or they may English as their second language, and they can't exactly express in written format. And so what I would like to do is listen to those people, watch them, hear how they are, and then make a determination as to what's best suited for the children. But absolutely no, it's not bitterness, and I've actually never appeared in this department, so I have no personal grievance against him, just my understanding of everything that's gone on in that courtroom.
Thank you very much. Councilor Brown?
I just have kind of a practical question. If you had a magic wand and you could choose one thing that you would change, and it could be, making 2 metal detectors, to get into family court, or it could be adding 2 more judges, or it could be, adding a copy machine on the first floor. So it could be practical or kind of institutional, whatever. If you could change one thing, what would you do to make family court more efficient and more fair? What do you think, where would you get the most bang for your buck?
Well, that's hard to just pick one thing, because I think that there's a lot of things that can change. But one thing that was talked about earlier today is with regard to the interpreter services not being provided to litigants. A lot of times we have litigants that are indigent. They can't even afford the filing fee or attorneys or anything else, and yet the interpreter's office won't send anyone unless they're being paid by the parties. And so I think that that's a problem that we need to address, and to make it more efficient. I mean, if I could wave a magic wand and make family court more efficient, I think the e-filing system has a lot of problems. You file a motion and you're waiting days and days and days to find out when the hearing is, when it might be an emergency situation where you have a child who may be in danger. So I think the e-filing system absolutely needs to be looked at and changed.
Good answer.
Thank you, Colonel Cotton.
Mike, I'm asking you maybe to be a Solomon, but a lot of times in divorce proceedings, both of the parents will use the other parent abuse the child as a way to kind of win in the court. You as the judge, can you tell me kind of how you would make those Solomon sort of decisions?
Yeah, it's hard, and as I've practiced a lot in criminal defense, and I've seen false allegations like you wouldn't believe. A lot of times there's false allegations of abuse, spouse to spouse, spouse on child. If there's an allegation of abuse, I think that it absolutely needs to be addressed and looked at, and CPS, if they're involved, what interviews, look at all the reports that they have done. I mean, I can't, as the judge, magically know who's telling the truth and who's not. But if there is evidence of abuse, then that needs to be addressed. The child's safety is the absolute #1 concern. However, I am cognizant that there are false allegations that are made, and sometimes abuse, if it's a slap on the face or something of that nature, it may have just been a one-time thing, and if that parent has services available, then I think that we should provide services for the parents to not conduct themselves in that way again. Because sometimes it's the abuse allegations, they're greatly exaggerated. So I think that I would really look at all of the evidence of abuse, and hopefully that CPS is involved and there'll be reports and interviews. If there's pictures, anything that substantiates the abuse, then it absolutely needs to be addressed so that the child's safety is taken care of. That's the #1 concern.
Thank you very much. Mrs. Bryant.
I need a mic, I don't have it. Thank you. 58,000 children every year are court ordered to live with a parent who abuses them. That's about 4 a day in Las Vegas. Of those, one about every 4 days is going to be murdered following these court orders. What are you going to do so it doesn't happen in your courtroom? How are you going to look at child safety first?
Well, as I stated in the last answer, it's hard when you're a judge. You have to be fair and impartial and be cognizant that sometimes allegations are false. We do have a constitutional right to parent our children if there's no unfitness. That being said, if there is evidence of abuse, the child needs to be taken out of the home until there's a safety plan in place to protect that child. Just because a parent has abused a child once doesn't mean that they lose their parental rights forever. But services need to be provided with appropriate counseling, psychological services for the parent, and to make sure that this doesn't happen again. We can't just take kids without any evidence, and we can't just take kids forever if there's a chance that this parent can be rehabilitated and be a good parent. Because if we don't get the parent services, they could have more children, and then we've only removed the one child, but then we have to go through it all again. And I think that a lot of that can be avoided if we focus on treating the parents who may have been abusers and fixing that problem from the core, so it doesn't go on to other children that may not have been removed from the home. But certainly, if I, as a judge, see and believe that a child's life or safety is in danger, then I absolutely would remove that child until such time that the parent has proven themselves.
Thank you very much. Mr. Moderator.
Ms. Levy, I've heard nightmare stories.
Levy, I'm sorry.
Levy, I'm sorry. About cases in family law court where some of the litigants or pro se parties basically do spaghetti law and just throw anything that sticks. They don't follow the procedural rules of NRCP or the family law rules as well. What would you see that you could do to make sure that the litigants did follow the rules, or what type of changes would be needed to make sure that they could file them properly?
Rules are very important, and in civil and criminal, they are followed much more so than in family court. I attribute that more to persons that can't afford attorneys. Family law attorneys are very expensive. And I think that there's some circumstances where you need to overlook procedural faults and get to the substance of the problem. So I'm okay if someone doesn't absolutely follow the letter of the rule. If it means that that person's the better parent, then I think that that's more important, finding out the substance rather than the form. Now, what I would also say is that I think that with the self-help center and the clerk's office, if somebody is filing something improper person, those people aren't able to give legal advice. But I think that there should be a form that's passed out to them detailing the rules that they are expected to follow procedurally, and that even if they're not represented by an attorney, those rules do apply to them. And I think that the self-help center, which has forms that people can purchase and write their own motions, should do the same thing and explain to these people, these are the rules that you must follow. Depending on the judge, your case could get thrown out if you don't follow those rules. I am a big believer in the rules, the evidentiary rules and filing deadlines when it comes to civil and criminal court. But as I said, with family court, when you're dealing with people that can't afford anything, and we're talking about the things that matter most in their life, where they could lose their children or the property that they've worked so hard for, I think that sometimes it's better to overlook some of the procedural faults and just get to the substance, because that's what's important in family court.
And in doing so, if it costs the other side more attorney's fees because of those procedural defects or defaults, would you be willing to award sanctions or attorney's fees to the other side to equal the playing field?
I can't see procedurally if somebody files something late or serves something late. I can see something like that, but if we're dealing with someone who doesn't have anything to begin with, it's kind of hard to issue a sanction. I mean, I'm certainly, if the other side can say, look, because of this procedural fault, it cost me 2 extra hours in attorney's fees, I can say, okay, well, those 2 hours are going to be sanctioned on the other side. But, I mean, you can't sanction someone thousands and thousands of dollars when they have nothing to begin with, and they're just there to fight for what they believe in.
Thank you very much. Ms. Daspot.
For those kids that appear before you in foster care, is there anything that you'd like to improve in the court?
Yes, with foster care system, I think sometimes it takes so long to get someone placed in a permanent home. If it's a child that's looking towards adoption, I think that process should be streamlined a little. In order to qualify to foster, it takes several months, if not years, to even get qualified. And I think there's several loving people out there who are willing to foster, but it just takes so long to get on the list and I have friends that are going through this right now who are looking to adopt a child, and I've seen all of the red tape that they have to go through, and these are two loving people with no problems in their background whatsoever, and it's taking them so long just to get placed on the list to get a child. So I think that those procedures should be streamlined when you have people who are willing to give children in need of a foster home or a permanent placement. I think that it should be streamlined for them to get on that list faster.
Thank you very much. Mr. Tenner.
Thank you. Good morning, ma'am. Thank you for coming.
Good afternoon.
I would like to find out a little bit about how you constitutionally think from a legal point of view.
Okay.
So I'd like for you to tell me, one, if you are a strict constructionist? And if you're not, or you don't want to answer that question, which Supreme Court justice do you think represents, or that you agree with, in terms of constitutional thinking?
That is a very difficult question. I believe wholeheartedly in the rights guaranteed under the Constitution. I spend a lot of my practice defending our individual rights, particularly under the 4th, 5th, and 6th. Those are the ones that I've dealt with most frequently. I am a big believer on the right of all of us to feel secure and safe in our homes and with our belongings against unreasonable search and seizure. So I don't know that I'm a strict constitutionalist or a constructionist, but I do believe greatly in our constitutional freedoms and our rights. With regard to the Supreme Court justice, I don't think I think like any one of them. I agree with Stevens on some issues. I'm kind of middle of the road, I guess you would say. But I think probably a little bit of each of them. There's some things of even Scalia that I would agree with. There's each of them a little bit of, I can't say I'm like one of them, but I have my own opinions. Let's put it that way.
Thank you much. And Mr. Ahern.
Good day, Mr. I was looking through some of your websites. I saw that you were dedicated to children and dedicated to change, which is something you had posted on there.
Right.
We've heard dedicated to change before, I believe. So my question is, oftentimes here, specifically in the Las Vegas community, there are teenagers who are not getting proper treatment psychologically. And I've seen this in my extended family. And oftentimes they're then being spun out into the world of adults, and they're not quite adults yet. And they're left to become victims. So on the theme of dedication to change, would you be willing to lobby from the bench to create new programs for these children before they end up in criminal court?
When you're a judge, you can't lobby. I mean, you have to be fair and impartial, and you have to, you can testify about certain things, but you really can't state your position on something that might come before you as a judge. So with that being said, I understand that the youth needs proper services, and in the juvenile justice system, I think that we need to focus more on rehabilitation than on incarceration and punishment. Because if we don't deal with this when they're in the juvenile system, and I see it all too often in my practice where I have a client who's got an extensive juvenile record, and they may have been given probation or sent to the Nevada Youth Training Center in Elko for a time, and they came back, but they were never really given proper psychological services or treatment for any drug or alcohol abuse. I'm a big proponent on services for our children. I have a child who has Down syndrome, and that's a big part of my activities in the community is standing up for her because she's not able to stand up for herself. And the same is true with our children who come from either abusive and neglected homes or children that end up in the criminal justice system because that's what they've been around their whole lives. And it's just, it's a family thing where the parents may have been involved in the criminal justice system and it trickles down to the children. And I think I'm a big proponent on providing services to try to treat people instead of just incarcerating them and housing them.
Thank you very much. And this now concludes the interview for Family Court Department N with Kenneth Levy. Thank you so much.